Today I want to discuss the Ahmaud Arbery case. This is the shooting of the young man who was unarmed down in Brunswick, Georgia in February of 2020. So what I want to do is go over some of the undisputed facts that we know thus far, no speculation, no conjecture, as well as go over some of the applicable criminal statutes that may apply in this case as well. So really the first question that we have to answer is, was there a crime committed by Ahmaud Arbery on that particular day? Because that's going to drive the entire conversation in this case. It's going to determine whether or not the defendants can even use the citizen's arrest statute under these particular facts. So let's start with the crime of burglary. There's been a lot of discussion of whether or not Mr. Arbery was potentially guilty of burglary when he entered onto that property without authorization. So let's look at the burglary statute, which is OCGA 16-7-1, which reads, a person commits the offense of burglary in the first degree when, without authority and with the intent to commit a felony or theft therein, he or she enters or remains within an occupied, unoccupied, or vacant dwelling house of another. So it's already undisputed that Mr. Arbery entered onto that property without authorization, essentially. It was shown on that video that's come out in the public domain. He was in the property for about 3 minutes and then he left. But the key question is, did he have the intent to commit a felony or a theft therein? And so the video also shows that he didn't take anything from the property. He stayed for about 3 minutes and then he left the property. And so we can show, and prosecutors can demonstrate intent by a variety of ways. So again, the easy way to show intent to commit theft is the person takes something. We know based on the evidence thus far, there was no intent to commit a theft. The question is, was there intent to commit some other felony on the property, such as arson, robbery, some other type of felony as well, to meet the burglary statute? And again, there's just no evidence that we have thus far to show that he had that requisite intent to commit a felony on the property. He was there for a few minutes. He was looking around, probably like many of us have done at some of these vacant construction sites, and then he left. Based on that, I don't think there was any burglary. I don't think any reasonable or fair or competent district attorney would ever have charged him with burglary under these facts. The only other potential crime that we could consider is the crime of trespass, which is a misdemeanor. And so he probably was guilty of trespassing. He didn't have authority to be on someone else's property. But again, that's a misdemeanor, and that's going to be key when we look at the citizen's arrest statute. But once again, I don't think there's a reasonable DA out there that would have charged him with criminal trespass, even as a misdemeanor, under these facts. Let's talk about the citizen's arrest statute and what that means, because I anticipate this is going to be the primary defense that the defendants will bring in this case, and basically say, hey, we made or attempted to make a lawful arrest under this statute. So let's examine this law. Again, this is OCGA 17-4-60. It says a private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. If the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. Based on the evidence that we have thus far, it's not clear that the defendants witnessed any crime committed by, or potential crime committed by Arbery in their immediate presence. In fact, they gave statements to the police that they just wanted to talk to Mr. Arbery, which again suggests that they didn't witness anything. They didn't witness any potential crime occurring. And there was also a 911 audio that has come out where basically the caller said they saw a black man who was jogging. Again, that's not a crime. That's certainly not a crime witnessed in the defendant's immediate presence. But let's assume, for the purposes of this video, that the defendants did witness Mr. Arbery commit some crime. Let's say trespass. Let's say they saw him go into the property without authorization and then come out of the property. Under those facts, could the defendants have pursued Mr. Arbery to potentially arrest him? not based on the law. They could not have. The only way they could have pursued him, they could have chased him, they could have potentially arrested him is if the offense was a felony, burglary, robbery, some felony. As previously discussed, trespassing is not a felony, it's a misdemeanor. So under this statute, under this law, the defendants could not have chased him, they could not have pursued him to arrest him under the citizen's arrest statute. So therefore, I don't think this potential legal defense holds any weight, and it's not going to hold up in front of an unbiased jury. So let's discuss one more potential legal defense that could come up in this case, and that is self-defense. There have been some claims by the defendants that Mr. Arbery charged at one of the men, and that's why he had to discharge his weapon essentially in self-defense to protect himself against Mr. Arbery. We already know there was a video taken by some third person that captured parts of that incident occurring and ultimately part of the shooting occurring. So let's examine this potential legal defense. We know based on the video that there was a chase. The defendants pursued Mr. Arbery and then essentially set up a roadblock in the middle of the road, which was illegal. You cannot stop your vehicle in the middle of the road. That is an illegal driving maneuver. After the roadblock was set up, one of the men jumped out of the vehicle and brandished this shotgun. And so what you need to know about self-defense is that you cannot claim self-defense if you were the initial aggressor. So for example, I can't walk up to someone, punch them, and then when they try to defend themselves against me, I can't pull out a gun, shoot them, and claim self-defense because I was the initial aggressor. So under these facts, after the defendants pursued him, chased him, set up a roadblock, brandished the shotgun, they can't claim self-defense in my opinion because they were the initial aggressors. The only person on that road that day who could have claimed self-defense and ultimately used deadly force to protect himself was Ahmaud Arbery, and he lost his life that day and will never get to tell his side of the story. So rest in peace to Ahmaud Arbery. I hope we can get some justice for him.